ready to move forward. You've made the decision to file for a divorce in Wisconsin, or maybe you're preparing for that moment when you finally do. And now you're wondering, how long will it be? Is it 120 days like everyone else says? Can it be faster? What if we agree on everything? Or will it drag on for a year or more? Well, I'm Jeff Hughes, lead attorney and CEO at Sterling Lawyers, and we have helped thousands of Wisconsin families navigate divorce from start to finish. And we've seen timelines go from 4 months to 4 years. In this video, I'll walk you through exactly how long divorce takes in Wisconsin, what affects your timeline, and what people miss that can cause serious delays. Well, let's jump into it. The minimum timeline in Wisconsin is 120 days, and by law, that is the required waiting period. So let's start with the shortest possible scenario. By law, Wisconsin has a mandatory 120-day waiting period before a divorce can be finalized. And that's about 4 months, and that is the bare bones minimum. And here's what many people often miss. The clock starts ticking only after the other person is officially served with the paperwork, not the day of filing. Even if both parties agree and you have filled out the paperwork correctly, the court cannot finalize your divorce before that 120-day mark. And for the vast majority of people, that is just the beginning. Most divorces take 6 to 12 months and can be a lot more. In our experience, most Wisconsin divorces fall within that 6 to 12 months time frame. And here's why. Court schedules are often backed up, especially in large, high-volume counties. Oftentimes, spouses don't agree on the terms right away, and it requires time to negotiate a good resolution. And there's also the required process that takes time, like mediations, guardian ad litem appointments, and so forth. I recall a case once where a client came in thinking they'd be done in 4 months, but it turned out they disagreed on child placement, which triggered a mandatory mediation, which did not result in settlement, which then triggered the appointment of a guardian ad litem, and that required an investigation and multiple hearings, which ended up taking 14 months. They didn't do anything wrong, but they were completely unprepared for how much each disagreement would slow things down. So what about an uncontested divorce? That's a 4 to 6 month divorce, and that is very, very possible. And it requires both spouses to agree on everything: property division, custody, support, and it also helps when they file jointly and don't contest anything. If that happens, yes, you can get your case done right past that 120-day mark. But here is what needs to happen. All paperwork must be done correctly, all financial disclosures completed and accurate, and the court must have availability on the calendar. So plan in advance, get your stuff in as quickly as possible so the court can schedule that final hearing right after the 120-day waiting period elapses. There is another option under Wisconsin Act 40. You may both be able to finalize without a hearing if you're both working with attorneys or you're both working with a certified attorney mediator. This new law lets couples sign affidavits and skip courts entirely, and that is a big, big win for a cooperative divorce. We had a case where a couple used Act 40 to finalize their divorce just a week after the 120-day waiting period ended. No court appearances, no drama, and they handled everything through attorneys, and the judge approved it on the spot. Now let's switch over to a contested divorce. These divorces go 6 to 12 months and often longer. And a contested divorce is one where there's a disagreement on any of these issues of property or debt division, custody or placement, maintenance or spousal support, or child support. And when there is a fight on these matters, you're looking at 6 months at least, and often much longer. So here's why contested divorces require so much time. First, there's discovery. That's trading of information. That's exchanging information with the other party. And that can look like financial disclosure statements, document requests, and sometimes expert witnesses get involved. Then there's also mediations, guardian ad litem appointments. If you can't agree on custody, the court requires mediation. If that fails, a guardian ad litem is appointed. Now, a guardian ad litem is another attorney appointed for the best interest of your child. Then there's court scheduling. Sometimes the courts get very congested and they are booked out months in advance. And then there's uncooperative spouses. If someone delays, misses deadlines, refuses to settle, this all can add serious, significant time. This case comes to mind where the other spouse flat out refused to turn over financial documents for almost 6 months. The court had to compel them, and it extended the case by nearly a year by the time the dust settled. Even though that case was supposed to be a simple divorce, that other spouse did everything possible to make it a complex divorce. Now let's shift over to now the divorce is over. So what about the 6-month marriage ban? Well, first, there's a 6-month remarriage ban in Wisconsin. And here's what many people don't realize. In Wisconsin, after your divorce is finalized, you cannot remarry for 6 months anywhere in the world, not just in Wisconsin. Now, this is a holdover law from many decades ago, but it's still enforced. And if you remarry during that time, the new marriage is considered invalid. But the divorce timeline is just one part of what you need to plan for. The bigger question most people often ask is this: how much is it going to cost me? Because it's not just the court filing fee, it's the attorneys, the paperwork, the delays, and sometimes surprise costs that can hit in the middle of a case. In this next video, I will break down exactly what a Wisconsin divorce costs and how to avoid the fees that can spiral out of control. So let's talk it through.